Hello, everyone. Great to see you. Thank you for joining us here at Fordham Law School. My name is Olivier Sylvain. I am a professor here at Fordham. I'm also the director of the McGannon Center and the academic director of the Center of Law and Information Policy. It's so wonderful to see so many of you here. It's so wonderful to know that so many people have decided to register for this event. It's really no surprise in consideration of Joel's substantial influence around the world between judges, colleagues in academia, civil society organizations, advocacy organizations, and people who just are curious about the impact of information flows on our society and economy, that so many of you would join us. I want to just say a couple things before we get the program started. I want to thank first all the panelists. You'll meet them later, but I want to express gratitude to Judge Shin for giving us the benefit as remarks for this first inaugural Reidenberg lecture. We will also hear from Pascal Reidenberg later on, and then our panel will start. I also want to acknowledge Ari Waldman, who had the foresight to think about celebrating Joel before he died, and continuing that effort now. Joel's impact was deep and broad. I just want to say that I'm lucky that I feel that I learned from him and that I was in his orbit. And at this point, I think what I have to do, it's a formality because this is also a CLE event. Joel was substantive after all. Chanel, can you, so this is the only time I think we're allowed to show the CLE code. We expect that people start at the beginning. And the CLE code is AJR21. I'll repeat it, AJR21. So I think, Chanel, you can take that down. I want to now introduce Dean Diller, who will say a couple words.
Thank you, Olivier. And I just want to welcome all of you today, the family, friends, colleagues, and students of Joel. And I also want to welcome all of those of you who didn't get to know Joel, but who are interested in learning about the field of information law, because it's great to have you with us today. And Joel would have wanted you to get the message and to dig in and and pursue the field. I particularly want to welcome Joel's wife, Dr. Pascal Reidenberg, who's with us today, and his sons, Jeremy and David, and their families. And let me just say to all of you Reidenbergs, we offer today's program and this series as an act of love and gratitude to all that Joel brought into our lives. On behalf of Fordham Law School, it gives me tremendous pleasure to introduce this new lecture series, and I can't think of a better way to honor Joel. Gathering on Zoom, it's befitting in a way because Joel was always ahead of the curve on all things technological, and I'm sure he would have raised some probing questions about it. Joel passed away almost a year ago. We miss his friendship, his energy, his sense of humor, his enthusiasm. All of this would have helped us get through what has been a very, very tough year. But beyond that, we miss his intellect, his curiosity, and his insights in helping us to understand our world as it is emerging from the pandemic. So I wish I could hear his thoughts on a wide range of subjects. And this lecture series is offered in that spirit as a means of sharing ideas and insights about the changing landscape of information law and enabling us to learn from leading scholars, judges, and lawyers. First, let me just say a few of the basics. Joel came to Fordham Law in 1990, so over 30 years ago. Over the course of 3 decades, he was a pioneer in examining the implications of the rise of the internet for our culture, economy, and in particular, our legal system. He was one of the first to recognize the centrality of the challenges to our personal privacy and explore the threats to privacy posed by government surveillance of the digital world, social media, online gaming, electronic student data, algorithmic decision-making, and other things which we are now familiar with, but which were new to us when Joel started to work in the field. He built a world-class information law program here at Fordham Law and founding CLEP, the Center for Law and Information Policy, in 2005, and spearheading the creation of our LLM program in IP and information law. Joel was a New Yorker, but he was also global, and it was important to him to be in conversation with and to reach scholars across the world. Joel's legacy lives on through the work of his students and scholars whom he mentored, and through the continued relevance of many of his touchstone publications. Earlier this month, the Berkeley Center for Law and Technology held a major conference on how Joel's insights in his groundbreaking article, Lex Informatica, which was published in 1998, have played out over the past 20 years. This lecture series extends Joel's legacy at our school, and I'm so grateful to Professors Olivier Sylvain, Ari Waldman, and Ari is at Northeastern now, and to Tom Gordon, the executive director of CLEP, for bringing us all together. And I know the tremendous amount of care and thought that you put into today's program. I'm also grateful to our panelists and, of course, to our speaker, Judge Denny Chin, whom I'll introduce shortly. But before I do that, I want to turn the podium, or whatever the Zoom equivalent is, over to Dr. Pascal Reidenberg. Thank you all.
Thank you, Matt Diller. Thank you so much for inviting me today and for honoring Joel's memory with this inaugural lecture. As you can guess, Fordham Law School played an important part in Joel's life. The 30 years Fordham story started, in fact, on a very happy note. About 2 years after I married Joel and I immigrated in the US, Joel decided to switch from working in a law firm to an academic position. We were living in Washington, DC at the time, and I was expecting our first child. Jeremy was born on December 12, 1989. And Joel had an interview for Fordham Law School on December 13 in the morning. He hesitated to go as he felt bad to leave me the day after our son was born. And I remember telling him, go, just tell him why you are so exhausted. It might bring you luck. And obviously it did. Joel had many happy years at Fordham and like the different function he had there. He enjoyed teaching and helping students over the years, but also working for the LLM program, for the Senate, and creating CLIP. Joel passed away 1 year ago now. It does not feel real. Joel was so full of life. As I have said previously, his legacy was really his love for life. He was an incredible fighter. He loved his family, valued friendship, and enjoyed his work and colleagues. I want to take this opportunity to thank all the colleagues and students of Joel who came to visit him when he was sick, and those who sent many letters and emails. I want to thank all the participants today, especially Judge Chin, Olivier Sylvain, Ari Waldman, and Tom Norton, and Dean Matt Diller. Along with my children, David, Jeremy, and his wife, Kathleen, we are incredibly grateful to know that there will be a lecture in Joel's name every year at Fordham. Joel would really have loved that. Thank you.
Thank you, Pascal. And at this point, I'm delighted to introduce the Honorable Denny Chin of the United States Court of Appeals for the Second Circuit. And I can't think of a more appropriate inaugural lecturer to launch this series. Judge Chin's connection to Fordham goes back even further than Joel's. He's a 1978 graduate of our school and has taught as an adjunct professor for more than 30 years. And he's currently a member of the University Board of Trustees. Judge Chin was born, in Hong Kong. His family immigrated to the US when he was 2. After practicing in a large firm, the US Attorney's Office, and a small firm, he was appointed to the federal bench in 1994 by President Clinton and to the Court of Appeals in 2010 by President Obama. He was the first Asian American appointed to a US Court of Appeals outside of the Ninth Circuit. On both the district court and the circuit court, Judge Chin has had a knack for drawing high-profile, critically important cases, everything from the sentencing of Bernie Madoff to the Trump subpoena case last year. And this is true as well in the area of information law. He presided over the Google Books case when he was on the district court, and his dissent in ABCB Aereo became, in essence, adopted by the majority of the Supreme Court when it heard the case. Judge Chin is a longtime friend and colleague of Joel's and has served on the advisory board of CLIP. And so, Judge Chin, I can't think of a more fitting inaugural lecturer than you, and thank you so much for joining us today.
Thank you, Dean Diller, and thank you also to Pascal. We come together virtually today, miles apart, but joined by our love and respect for our friend and colleague, Professor Joel Reidenberg. I am honored to have been asked by Dean Diller and the law school to give the inaugural Reidenberg lecture. This is actually a daunting endeavor for me, not only because so many of Joel's friends and family are listening, but because I am to be followed by a panel of experts. And I am no expert on information and data law. But as Joel would do, and Pascal referred to him as a great fighter, I will forge ahead. As you heard, Joel founded CLIP in 2005, but he did not put together a board of advisors until 2010. He invited me to join, and I was honored to do so. And ultimately, the board included Judge Marsha Berzon of the Ninth Circuit, Judge Marilyn Patel of the Northern District of California, and Judge Theodore Jones of the New York State Court of Appeals, as well as experts on information law, cybersecurity, and privacy. We were all excited to be a part of what was clearly an important and innovative endeavor. And of course, we all wanted to work with Joel. Because Joel helped introduce me and so many other judges to the world of information and data law, I thought I would talk today about judging and information, data, and technology. Of course, as a preliminary matter, we judges are not known for our skill with technology and social media. Like many of my colleagues, I am not on Facebook or Twitter or LinkedIn, and I can't keep up with the likes of TikTok, Instagram, or Snapchat. In fact, until the pandemic hit last year, we judges at the Second Circuit were still using the fax machine to share drafts of opinions. In the early days of the pandemic, although we were all working remotely, we kept sending faxes. I went into chambers one day, and with no one there to tend to the fax machine, I found a massive pile of paper. Our fax machine had become overrun with faxes. I am pleased to say that the fax machine has now fallen victim to COVID-19 at the Second Circuit, and we will no longer be sending each other faxes. And our court is not the only one that has occasionally seemed to be behind the times. When one of my cases, and Dean Diller alluded to it, ABC versus Aereo, went up to the Supreme Court and was being argued in 2014, the lawyers and justices resorted to using simple analogies. Aereo was a copyright case involving the retransmission via streaming of over-the-air copyrighted television programs. The question was whether Aereo was engaging in the public transmission of programming. Although this was a case about new and innovative technology, Justice Breyer found himself asking a question about a phonograph record store. And one of the lawyers tried to explain the concepts in question by referring to the difference between a car dealer and a valet parking service. Things were so bad, by the way, that Joel was asked by the Federal Judicial Center some 10 years ago to develop a program for federal judges on the basics of internet technology, Internet 101 for judges. In 2014, when Joel was teaching at Princeton, he invited me to join him there on a panel on judging technology. Also on the panel were Judge Jeremy Fogel, a district judge from California, who was also then the director of the Federal Judicial Center, as well as a justice from the Supreme Court in France. With Joel moderating, we explored the challenges of applying decades-old statutes and long-existing legal principles to new technologies. As society moved, for example, from broadcast television to Cablevision to the Sony Betamax to the DVR to streaming to the cloud, did the old rules still apply? To what extent was Congress's intent when it passed a law half a century ago still relevant today? Has the concept of reasonableness for purposes of the Fourth Amendment changed as technologies and surveillance and tracking devices have evolved? And what about the impact of technology on the presentation of evidence and argument in the courtroom? At CLIP, we addressed these and other questions as Joel introduced us to a number of new and innovative concepts. At one point early on, at one of its annual conferences, CLIP presented a program on the Internet of Things. I was not then familiar with the term. That was not surprising, but when I asked my law clerks, recent law school grads, who should have been more tech savvy than me, they also did not know what it was. Joel's program explained this notion of a network of things, physical, everyday objects connected by the internet and working with each other. I remember the example of an alarm clock connected to the internet so that if there was a traffic jam on my route to work, a signal would be picked up somewhere and then it would be transmitted to my alarm clock, which would then reconfigure itself to wake me up 15 minutes early so I would not be late for work. At another CLIP conference I attended, there was a panel on fashion and data. The phenomenon, for example, of collecting data as to a customer's likes and dislikes and using that data in marketing, even while the customer was still in the store. Today, of course, the use of data analytics in fashion is commonplace. If I do a search on Amazon for a rain jacket, for example, for days afterwards, I will be bombarded with ads about rain jackets. But Joel and CLIP were exploring this way before data analytics and fashion became commonplace. And at yet another conference, CLIP presented a program on the government's access to and use of locational data. This was 10 years ago, long before the Supreme Court's decision in Carpenter versus United States, which held that accessing historical cell site location records is a search subject to the Fourth Amendment. And because of Joel's expertise, CLIP was asked to conduct a number of studies that would have a substantial impact. CLIP did a study on children's education records and privacy, for example, that the US Department of Education put to good use. CLIP received a grant from the World Intellectual Property Organization in Geneva. The New York State Consumer Protection Board asked CLIP for assistance on a project. Again, these studies took place years ago, and they explored issues before the issues became well known. And there has been much more since. I was surprised to see, for example, an article in the Los Angeles Times in January 2020 that quoted Joel. By then, of course, he was deep into his struggle with his illness, but there he was commenting on the collection of data by a supermarket chain when shoppers use coupons in a loyalty program. By the way, I have noticed that when we are at our country place in upstate New York and we shop at the local supermarket where we use a loyalty card, for some reason, I keep getting coupons for Haagen-Dazs ice cream bars when we check out. Joel is famously known for the assignment he gave his students one year on Justice Scalia. This was 2009, and Joel was teaching his course on internet privacy at the law school. Justice Scalia had made some comments at a conference dismissing concerns about internet privacy, apparently even calling the concern silly. Joel, who the year before had given the same assignment to his class with himself as the focus, asked the students to see what they could find on the internet about Justice Scalia. Well, what did the students find? They found Justice Scalia's home address, his home phone number, his wife's personal email address, his favorite TV shows and foods, 15 pages of very personal and private information. Of course, the concerns raised by Joel were very real ones. And again, Joel was ahead of his time. I recently served for several years on the Security Committee of the Judicial Conference of the United States Courts. And the security issues presented by the internet for judges were a constant struggle for our community. The New York federal judge who presided over the Silk Road trial had her private information revealed on the darknet, and she and her family were subjected to death threats. And tragically, last summer, the son of a federal judge was killed, and her husband wounded by a gunman at their home in New Jersey. The judge, the Honorable Esther Salas, has been incredibly courageous. As she recently wrote in a column published in the New York Times, after Daniel's death, I learned from FBI agents that it's easy to find personal information about judges on the internet. Judges' addresses can be purchased online for just a few dollars, including photos of our homes and the license plates on our vehicles. In my case, this deranged gunman was able to create a complete dossier of my life. He stalked my neighborhood, mapped my routes to work, and even learned the names of my best friend and the church I attend. Judge Salas decided to speak out to support the passage of a proposed federal law, the Daniel and Earl Judicial Security and Privacy Act, which will seek to protect the personal information of federal judges, including allowing judges to redact information from certain websites and barring data brokers from selling the information. The bill should pass easily, but even if it does, unfortunately, the problem will not go away. Once information is out there on the internet, it is hard to scrub it completely. And the bill does not include a preemption provision, and thus it will not preempt state law, and individual states will be able to do what they want to. There is an ongoing effort to pass similar legislation in New York. We'll see what happens, but Joel saw this as a serious issue many years ago. Joel accomplished so much in his too short life. There is much to remember him for. But when I think of Joel, the first thing that comes to my mind is his smile, his broad, beautiful smile. He was so happy and enjoyed life so much. We saw that even during his 2.5-year battle with his illness, as he was so positive and cheerful and brave in his periodic email updates, emails that were both heartwarming and heartbreaking at the same time. Joel was an inspiration to us all. He was a trailblazer in so many ways. I know that the members of Joel's family, including his wife Pascal and his sons Jeremy and David, are immensely proud of him. We will miss him.
Hello, everyone. Thank you all for joining us today for this fantastic series to pay tribute to Joel. I'm Tom Norton, Executive Director of CLIP, the Center on Law and Information Policy. First, I'd like to thank Judge Chin for those wonderful remarks. A truly fitting tribute And also I'd like to thank you for being such a champion of Fordham Law School and of CLIP. It's truly an honor for us all to have you here with us today to deliver the inaugural Reidenberg lecture. So thank you. And although your remarks would be fitting and standing enough on their own, we're also very lucky to be joined by a wonderful slate of panelists who I'd like to introduce now. In addition to being renowned experts in privacy and information law, the panelists are Joel's colleagues, collaborators, and also his friends, whose work Joel highly respected and admired. They're Margot Kaminsky, Associate Professor at the University of Colorado Law and the Director of the Privacy Initiative at Silicon Flatirons. Paul Schwartz, the Jefferson E. Pizer Professor of Law at Berkeley Law and the co-director of the Berkeley Center for Law and Technology. Daniel Solov, John Marshall Harlan Research Professor of Law at the George Washington University Law School and the founder of Teach Privacy. Catherine Strandberg, Alfred Engelberg Professor of Law at NYU Law, the director of NYU's Information Law Institute and Interdisciplinary Privacy Research Group, and also faculty director of the Engelberg Center on Innovation Law and Policy. And finally, our moderator today is Ari Walbin, Professor of Law and Computer Science and the faculty director of the Center for Law, Information and Creativity at Northeastern University. So thank you all again. Thank you, Judge Chin. Joel would love this. And with that, I turn it over to Ari and the panel. Thank you all very much.
Thanks, Tom, and thank you, Judge Chin, for those beautiful remarks, just echoing Tom and I'm sure everyone else here. It is my pleasure to moderate or kick off this panel to honor Joel's contributions and legacies, not just to us personally, but also to our field. So I met Joel years ago when I was just starting out as a legal academic. He noticed me sitting alone at a table at my first Privacy Law Scholars Conference, which is the largest gathering of our community, always in June, that Dan Solov and Chris Hufnagel created about 10, 11 years ago. And he came over and introduced himself. And from then on, he was one of my central and super important mentors, both professionally as well as intellectually. And I had a wonderful opportunity to work with him on many occasions and meet his family. And then it was bittersweet when I had a different opportunity when he got sick. I stepped into his role teaching his information privacy class at Fordham and got to meet his students and many of his colleagues. And I was hoping that this was just going to be a couple of years and then Joel would take it over and do a much better job than I was always able to do. But alas, that's not how things ended up. But it's still it's still a great opportunity for us to remember and think about Joel's legacy, which will, of course, live on. So I want to engage our panel in a little bit of a conversation, but I also want to hear from those of you in the audience. So please feel free to use the Q&A feature if there are any questions that you want to ask, and I'm sure our panelists will be happy to engage. So first, I'd like to ask each panelist, and I'll go in order of the way my boxes are arranged here, to think about something, one or two things, whether it's personal, whether it's scholarly, or some professionally, something about Joel that you think you will always take with you, whether it's something like a story that I just told about being one of my first mentors and someone who came over to me when I was alone, or something that inspired your scholarship. And I think this will be a great kickoff to show everyone how Joel will live on. So if we can, let's start with Kathy.
Thank you. Yeah, and it's great to be able to be here and do this, although it's very sad. And it seems very weird to me because I've been away from New York since before Joel passed away. And so I haven't seen anyone in New York in that year. And I keep having this feeling like when I go back, he'll just be there. And so it's a very strange, sad thing. But anyway, I thought I would mention two things. One very sort of trivial and personal, but one of the wonderful kinds of events that Joel and Clip would have at Fordham that I got to participate in quite a few times was, I've forgotten what they called it, but they would invite a scholar in and then they would allow them to invite two other people or so to bring them in, sort of a colloquium kind of thing. I just thought this was a fantastic idea. I wanted to steal it, but I didn't steal it yet. And I was able to attend many of them. And I think that was just wonderful. And then one of the best parts of it, besides the scholarly discussion and everything, was that afterwards we would always go over to Rosa Mexicano and have, most people would have margaritas. I don't drink, so I was really into the guacamole. That was my, like, those were wonderful memories of just having chances to relate to people and be together with them. And then I thought I'd mention a scholarly thing. So I actually went back before this to kind of like reread some of Joel's greatest hits. And of course, everyone is going to talk about, I mean, everyone would refer to Lex Informatica. That's just amazing foundational piece. One thing that really struck me looking back at Joel's work, some of his work over the years, and I don't think I had quite put this together in my mind until I did it, was the extent to which, although Joel is very critical about the effects of technology on privacy and on many issues, he always maintained this optimism about the ability that we might have to use technology to help us solve these problems. And I found that quite inspiring because I am sort of a technology fan myself with a science background, but I had become kind of jaded on that. And reading Joel's work really made me feel like, yeah, this is something we should keep trying to do. So I'll just stop after those two things.
Thank you, Kathy. Paul? Oh, you're on mute.
Thank you, Ari, and thanks for organizing this. You know, I'm gonna start off with something about the, just say something about the Justice Scalia kerfuffle, as Joel used to call it, and then maybe make some personal comments about my great friendship with Joe. So the Scalia kerfuffle, right, where he gave that class the exercise to find out information about the justice, was done in a very discreet fashion. None of the information ever leaked out. And Joel did not in any way contribute to kind of the store of available information. And it was interesting because the justice missed the point. He reacted in a very angry fashion. There's an article about it that mentions it by Joel in Loyola University Chicago Law Review, which I reread, called The Transparent Citizen. So Joel's point was the educable moment, as he writes, was how on all of us, there is an extensive dossier that is from publicly accessible sources on the internet. And so the justice reacted with a kind of angry quote to Above the Law blog that questioned Joel's judgment. But Joel's judgment was, I think, impeccable, which was all of this information is available about all of us and any of us. And that's what the law needs to react to. And in particular, as Judge Shin was telling us, there is a need to protect judges and to react to this situation. So, you know, great educable moment, and really illustrates something about Joel, which is that he was a fighter and also that he was non-hierarchical. And I love the story, Ari, about how Joel went up to you and during the memorial service for him after he passed away, which we had in May of 2020, I heard similar stories from international professors who had met Joel when they were a student And they started off with a conversation, and Joel said, why don't we continue it over lunch? So Joel was really interested in ideas, in their value. And it didn't matter if you were a Supreme Court justice, right, as in my previous example, or if you were a student, he was really interested in what you were thinking. Final quick anecdote, and this is going to be a more personal one, about what immense Joel was. And here's a book that we wrote together in 1996 that we did for the European Commission. And I just want to mention the book celebration that we had for it. Joel loved Fordham, and we had our 2 celebrations for the book publication. And this should bring a smile to Pascal's face as well. The first one, my father unfortunately was in poor health then. And so I came in from Queen, and I was a single guy back then. So we had a book celebration with my parents and Pascal. And the first one was with my dad, brought him into a deli near Fordham, and Joel and I had a celebration along with then Professor Bill Traynor and Marty Flaherty. And so the Fordham family and Joel and I celebrated the book with my dad. And then that evening at the beautiful romantic Café des Artistes, we had dinner with Pascal and Joel and me and my mom. And we celebrated the book, which I think is a great illustration of what a mensch was. Final thing, and I'm going to end on a substantive note. In the book, we write that this is 1996, folks, the narrow dispersed approach to information regulation in the United States assumes that the treatment of personal information will be limited to one context within a particular industry or company. In reality, here we go, company information practices do not neatly fit within the sectoral thinking. There is widespread cross-sectoral use of personal information. So bravo, Joel, that was your sentence.
And one of the things about Joel's scholarship is that his was 10 years ahead of the rest of us, right? Making recommendations that many people think they came up with out of the blue, but Joel wrote about 10, 15 years prior. Thank you, Paul. Dan.
I'll start just by noting that it seems like I've known Joel forever. When I entered the field, he was incredibly welcoming to me, and I barely had written anything, was just brand new, interested in this area, and an area that he had been writing on for more than a decade before. Was immensely welcoming, instantly was a friend and a mentor, and everyone he met, he extended that same kindness to, and he was incredibly generous and warm and engaged, always interested in talking about ideas, always eager to read and comment on scholarship. Really, the ideal of what a member of the Academy should be. One thing that's really struck me about Joel's scholarship, and I noted this early on when I started writing about privacy, and I started preparing to write about privacy and researching privacy in the mid-90s when I got interested in the topic, taking a cyber law class in law school. And I found, oh my gosh, there's a book, the very book that Paul showed, this book from 1996. And if you think about that, this is 1996. This is 25 years ago. They had written a book on this. The thought that there would be a book about this topic. I mean, there were so few things on privacy, so few articles. I remember hunting desperately to try to find stuff. I couldn't even find this book, actually. It was really hard to get. And then finally, I was able to get my hands on a copy. I couldn't even buy, it was hard to even get a copy. At that point, you couldn't really just get a copy on Amazon. So I remember getting this copy, and I confessed to a copyright violation. I went to the copier and I copied it page by page, the entire book, because I was so excited to get my hands on this book. And there's no other way to get it. Sorry, Paul. But it was incredible. Like, wow, like someone wrote a book on this. And then Joel had a bunch of articles. And if you look at the articles that he wrote and when he wrote them, he was writing about the significance of the EU long before anybody in the US cared about the EU, paid attention to the EU. And he wrote about the importance of the EU approach, the difference between the US approach and the EU comprehensive approach to privacy. And all this wasn't just written, if it were written 10 years ago, it would be, oh my gosh, this guy can see the future. This person's way ahead of his time. If it were written 15 years ago, people would have been amazed. If it were written 20 years ago, but this was even more than 20 years ago. This is what he was writing in the 90s. So it's amazing how ahead he was, and the things that he said about the EU and the significance of the EU approach is just starting to kind of become in vogue today in the US, where now suddenly the ills of the sectoral approach over the last few decades have been percolating, but all this is catching up to where Joel was so long ago. He wrote about privacy. I recently wrote a paper about privacy harms. Well, there's a paper by Joel about privacy harms and remedies from eons ago. So pretty much anything you want to write about, you can look and you can see decades ago Joel had thought about it and had made a contribution to it. He, in so many ways, talking about cross-border data transfers, again, writing about it from a very early point in time, writing about the importance of protecting privacy as a fundamental right. All this stuff is something that he was way, way, way ahead. And what he has written still stands the test of time. I'll still read what he has written and say, wow, that's still true today more than ever. The world is really catching up to Joel. And of course, I have to mention his most famous article, and I think the article that is just a crowning contribution, which is the Lex Informatica article. This article was written in 1998, and there are countless books and articles and a whole opus of work built upon his article. And I think it's often, it's an article that, even though I think it's gotten tremendous fame and credit, I think it's still not enough. He really did pioneer one of the key foundational ideas in the field, that code is law, as a later scholar phrased it. But Joel argued that the way that technology is structured, the way that things are coded really is key to how privacy is governed. And this idea is found in Privacy by Design. It's found in the works of just so many others have built upon this core idea, which Joel had thought about long before anybody was writing or thinking about these topics. And I think it's really incredible that he was able to not only come up with great ideas and lasting thoughts, but ones that were done so early on, before others were saying them, before anything was really happening, so far in advance that it's really quite astounding. Hats off to Joel for really doing a body of work that is, I think, a really remarkable and wonderful body of work by a truly wonderful human being, a person who was So kind and generous. He'll be really sorely missed, both as a scholar and as a person.
Thanks, Dan. And now we'll hear from one of today's most canonical scholars on the EU and data protection law, Margot Kaminsky.
Thank you, Ari. These are all hard acts to follow in so many ways. But the two notes I made about what I wanted to say about Joel and my experiences with him are big ideas and warm heart. And I think we've heard this from every single person on this panelist in some panel in some form or another. So on the big ideas front, as everybody has mentioned, every time that I start to write on a topic, I find that Joel has been there first. And I write on a lot of topics. So he was path breaking in a way that was really extraordinary. As Dan was saying, he wrote back in 1998, not only about technology existing as its own unique regulatory force, but also on the necessity of law to govern that regulatory force. And I think when we look at the really early conversations about the internet, we see a lot of optimism or even delusion about what the regulatory force of technology is going to be doing. So Joel had both a critical eye and, as Kathy mentioned, hope and faith in technology and what it could do, in law and what legal institutions could do to counter other social forces. He had an incredible eye and sort of brain for high theory combined with really nitty gritty applicable law. And that's something that's can be quite rare in legal research. So I remember when I read the transatlantic privacy piece, being in awe about how he could move so deftly between talking about fundamental theoretical and cultural differences in how the US versus EU member states operate as democracies, to talking about very small provisions, details of data privacy regimes. He had a curiosity of spirit. He was sort of in a mode of constant inquiry. So again, I felt like I was always getting to things 5 to 20 years behind him. And when I found that something was an interesting project, I'd always find that Joel had started the questions first. And here I'm thinking of his sort of enormous algorithmic accountability work that was done in cooperation with computer scientists. And then to the warm heart, I had a very similar experience to what Ari described. So I was a fellow for years before I became a law professor, and I was only a first-year tenure-track law professor when Joel invited me to be one of the featured speakers in the series that Kathy mentioned. And at the time, that was both intimidating and incredibly welcoming. So I remember showing up to this event and having the probably 5 or 6 professors whose work at the time I only knew on paper all sit around a round table reading my article. And there was another fellow at the time who was able to attend this, who came up to me afterwards, actually on the way over to Rosa Mexicano, to say they all treated you like a peer. And I just had this moment as a junior most law professor of thinking, the reason this happened is because of Joel. He made, as another person on the memorial event at Berkeley a few weeks ago mentioned, he made all of us feel like we belonged long before any of us belonged. And that is really the true legacy of somebody who is a leader, not just in intellectual endeavors, but in a field. So I am incredibly grateful to be on this panel. I think in many ways, I owe being on this panel to Joel. And thank you so much, Ari, for pulling this together and moderating and hosting us.
Thank you, Margot, and thanks to everyone. I want to dive in a little bit deeper to both of these sides, the personal contributions, the way so many of us related to and felt welcomed by and mentored by and was friends with Joel. And on the other hand, the way in which our professional careers and the field of privacy law were so indebted to Joel's contributions. So first, on the intellectual side, Paul already mentioned, and Dan talked about Lex Informatica and this canonical article about the way in which technology and norms are really part of the governing structure of our the cyber world in which we live in. But Joel wrote scores of other articles and so many pieces that, and I just did a cursory search right before this, that if you look at the work of not just the five of us here on this panel, but leading privacy scholars, junior privacy scholars, there's always a citation to one of Joel's work, one of Joel's article, or one of Joel's books or whatever. Even right up until he wasn't feeling well toward the end, Joel and I were writing an op-ed that was based on an article that he wrote in 1999, where he first suggested that the Federal Trade Commission, which is our de facto privacy regulator in the United States, is woefully incapable of addressing privacy harms in the United States, which now is a talking point for senators and for elected officials. So can you identify, for the other members of the panel, can you identify a particular article or a particular project that inspired your work? So I'll start as you think about it. One of them for me is that Joel, along with Tom and others, and this also speaks to his ability to bring people together and build coalitions and build groups of scholars together, he did an empirical study of the language inside privacy policies. And this is something that scholars now are doing. Like a group of scholars at Princeton started doing an analysis of language in privacy policies. And I mean, they're doing great work, but no offense to them, but Joel did that years ago, right? And he found that the use, he and his colleagues found use of very vague language like may and possible and in the future we might, things like that, would always be associated with or near words that would essentially open up extraordinary opportunities for data collection, right? So he identified particular language that the companies were using particular language in their privacy policies that allowed them greatest leeway while just skimming that line of illegality or skimming that line of unlawfulness. And Joel and I sat on a panel inspired by that work. I started thinking about not just the words, but the way these privacy policies look. And that was helpful in me starting to think about design and the role of what companies do inside their organizations to weaken privacy law. And a lot of that was inspired by Joel's work. And as a side note, a seminar in which Paul invited me to attend and give a talk in one of his classes. So Joel really spoke to, really inspired that kind of collegiality in our community. So I'm going to switch up the order here. So maybe we can hear from Dan first. If there was a particular article, a particular project that you felt inspired some of your work.
Well, there's so many, it's hard to pick just one. One of the things that just reviewing Joel's publication list, which I did recently, that I just still find just so amazing is because there really are countless articles that when I looked at the list, I remember very vividly and citing and being very influential. But I just want to just read a couple titles from the list and the date that they were written, because it's astounding. I mean, it just astounds me. Here's one: Privacy in the Information Economy, a Fortress or Frontier for Individual Rights. This article was written in 1992. That's 30 years ago, practically. So the Privacy Obstacle Course, Hurdling Barriers to Transnational Financial Services. This is 1992 again. He has the Setting Standards for Fair Information Practice in the U.S. Private Sector, 1995. Yeah, there's Governing Networks and Rulemaking in Cyberspace, 1996. Lex Informatica, which was 1998. Restoring Americans' Privacy in Electronic Commerce, 1999. Resolving Conflicting International Privacy Rules in Cyberspace, 2000. Privacy Wrongs in Search of Remedies, 2003. And I could just go on, but all this so far in advance is it's just really amazing. And all of these pieces, his work on the importance of the EU and the US sectoral regime. I remember really coming to understand the significance of this and the importance of this from Joel's work long before now, which I think it's very much common that folks talk about this and discuss this, and but it wasn't many years ago before the GDPR. This wasn't on many radar screens, and it wouldn't have been on mine. I really learned this from Joel. And the same goes with the cross-border transfer of data. It wasn't really an issue that I thought was that big. It wasn't, again, really much on my radar screen. And of course, today it's an enormous issue and an enormous challenge for countries around the world to transfer data to other countries. And we see that with the Schrems 2 case, where there's right now a lot of uncertainty and doubt about how to transfer data from the EU to the US. This is something that Joel saw so many years ago and was talking about before anyone really, at least in the US, seemed to care about it. There were a handful of other positions on it, but Joel also took positions that are, I think, ones that have strongly influenced me. And what's also amazing to me is that he was right about so much stuff. When I look at his articles and reread a lot of them recently, it's amazing how often I thought, wow, he was right so many years ago. They've really stood well the test of time. And it's truly amazing how right he was so far in advance. Not just that he saw the issue, but that he had really interesting things to say about those issues, productive, correct things that really still stand true today. And I think that's pretty incredible that if your article is still relevant today, still citable 30 years after it was written, still important, even though you were writing at a time that hardly anything was said about something, and still your positions are, especially in this field of technology where so much becomes obsolete so quickly. I don't know how many times I'll read articles from even 10 years ago and think, wow, that this article is so wrong. The technology has moved so far that the article is obsolete. What's amazing about Joel's work is that it isn't. It's still relevant. He managed to write about technology in a way that is very almost universal, or that stands the test of time, that can evolve as the technology evolves. It wasn't tethered to the particular technology of its day. And so I think that's why, people will read Joel's articles decades to come in the future. And for me, that's really a model for how I'd like my work to be. I definitely hope that, in the future, 20, 30 years after I wrote a piece, that it still would be relevant and not seen as archaic and, a historical artifact based on technology then. I really want my work to be like Joel's, and that's been a great model because he's done it time and again with so many pieces, and that's why I think his work is so significant.
Great, thank you, Dan. How about Kathy?
I think for this, I'll move to something more recent of Joel's work, which is his 2017 article, a collaborative article on accountable algorithms. This piece is, to me, a model in a number of different ways, and was actually one of a number of things that I read when I was sort of getting into thinking about this field as well, and was really influential in my own thinking. It's a model because of the interdisciplinary nature of the author list. He has on the author list, let's see if I can pull it up here. The author list includes Joshua Kroll, Joanna Hui, Solon Baracus, Ed Felton, Joel, Dave Robinson, Harlan Yu. So it's this, for people who might know some of those, it's an amazing collaboration of computer scientists, information science types, and legal scholars. And that is something that I definitely aspire to in my own work, my personal writing, but also at the Information Law Institute. So I find that incredibly inspiring. Also, just sort of along the same vein, I mean, the piece itself is just fascinating. If anybody works in this area and you haven't read it, read it, because it gives you a lot of really well explained information about the technology that I think, you know, a lot of times legal scholars writing in this area, we don't always know everything we should know about the technology, and vice versa. The technologists don't always know everything they should know about the law either. And I just wanted to particularly point to the last section of that article, which I'm trying to page to on my tablet, which is kind of slow. Okay, which is called Fostering Collaboration Across Computer Science, Law, and Policy, and gives some very specific recommendations for what computer scientists should do, what legal scholars should do. And I have myself thought a lot about that issue and put, you know, some thoughts on it into some of the things that I have written. But this is a great, you know, beginning for thinking about that issue. And I'll also say that another way this article inspired me, which I also think is often true of the best articles, is I don't agree with all of it. There are things in it that I didn't agree with and that I thought were, you know, too optimistic about what could be done with the technology. But that's also great. I mean, that's what you want in a good article. So I would point to that piece, which was 2017. So very recent.
Great, thank you, Kathy. Let's hear from Margot and then Paul.
Thank you. So my primary engagement with Joel was on the Resolving Conflicting International Data Privacy Rules in Cyberspace, which, as Dan pointed out, was published May 2000 in Stanford Law Review. And like Kathy, I was both inspired by his work and disagreed with it, and that actually made things more fun. So in that piece, parts I agree with, he talks about some fundamental cultural differences between the US and the EU, and some ways in which the two regulatory regimes are pretty irreconcilable. But at the same time, he calls for using a particular institution to try to harmonize across the Atlantic, which is international trade. And I had come out of looking at international trade through an IP lens, and had deep skepticism about the use of free trade agreements in general for trying to address what are, you know, human rights or fundamental rights concerns. And so I wrote, I think, a response, gosh, in like 2016 or 17, so 17 years after he published this, saying, I disagree with you. And he just was like an incredibly good sport about this and engaged with it. The other one I remember was actually the first time I saw Joel present, and that was a short piece that he wrote for the University of Miami Law Review called Privacy in Public. And that piece has been basically a must cite in the footnote piece for everybody who has since been trying to wrestle with balancing First Amendment rights to record in public with some sort of increasingly recognized at the Supreme Court level protection for activities in public. And he was one of the first movers in that space too. And again, I greatly appreciated what he wrote and largely disagreed with him, and it led to wonderful conversation afterwards.
Excellent, thank you, Margot, and Paul.
Okay, so so many lessons from Joel as a scholar and as a privacy entrepreneur, and let me quickly go through three. So first of all, one thing that I learned from working with Joel and reading Joel's work is how important it is to make the right comparison. And in a sense, all law is comparative. So when we were working on our projects, I held up the book before. We also did a second project for the commission of what was then the European Community we worked really hard on what we were going to compare. And so that was Joe really driving forward the matrix that we would use when we compared EU and US law. Our second project looked at diverging harmonization in the EU under the EU Data Protection Directive of 1998. And I say 1998, and Dan, just stop rubbing in how long ago some of these projects were. My gosh. Anyway, so we did our second project looking at diverging harmonization, and we looked at Belgium, France, Germany, and the UK. And again, it was really, really important throughout to think very carefully about what we were comparing. And I see this not only, I guess in a sense, all law is comparative law, because Joel was so good at looking at other fields of law beyond privacy, and really was a master of intellectual property and other areas. So make the right comparison. Second thing that I think I learned from Joel and his work is sticking to your vision, right? And Joel could be very stubborn and in a good way. And so I think that's why when Dan talks about going back and reading the articles and saying and seeing how much Joel got right, it's because he was stubborn in his vision. He stuck to it. And a great example for me was he predicted in an article, I believe it was a piece in the Houston Law Review, that the adequacy finding of the commission for the United States was on shaky ground. And I remember him telling me this about it at the time, and I really thought nothing would ever happen. And analytically, he got to that point and he wrote about it. And sure enough, Schrems 1 came to the same conclusion as Joel, which was that the commission was incorrect in finding that the adequacy finding was correct. Third and final thing that I learned from Joel was not only the importance of having an impact, or what Congressman John Lewis famously called good trouble, but I think how to have an impact. And so we've heard a little bit about this, and you know, from Judge Chin and others about how Joel set up conferences for the judicial branch. He also was someone who testified on numerous occasions before Congress. He was really good at finding cutting-edge issues. Example would be his work about ed tech. I remember as well, when we were doing our first report for the European community, how that took us on the same day to the West Wing of the White House, relatively early in the day, and to talk about our work for the European Commission, which the Clinton administration was very worried about. And then we went on later in the day to one of the few big law firms that at the time had a privacy practice. So this is about 1995. And Joe was completely charming throughout the day, and he had enormous energy. He also, as I said, stuck up for what he believed in. I remember him tormenting a fellow at the big law firm, and voices were raised. And what was most amazing about it was at this point in the day, I was completely exhausted, and I was just like barely following the discussion. But Joe, like the Duracell bunny, was still going full blast. So final thing is, you know, speaking about the West Wing, same thing when you look at Joel's CV regarding the world. And so I had the pleasure of seeing Joel navigate the corridors of the European Union in Brussels. And I should add here that Joel spoke French beautifully, to the point where, you know, French people would comment on it, how well he spoke. And so to be with Joel either in Paris or in Brussels just really showed you how talented and diplomatic he could be, while at the same time being very savvy and emotionally intelligent about causing good trouble.
Great, thanks, Paul. On that point, I want to spend what little time we have left, and for anyone in the audience, if you have questions, please don't hesitate to add them to the Q&A. So several people have used the Q&A to post memories and their particular memories of Joel, which is lovely. But if you also have questions, don't hesitate to ask. So the other side of Joel's contribution, of course, is his contribution as a human. And he has, I think, impacted all of us in that way, not only as setting an example for what a mentor should be or what a teacher should be and what an authentic mentor and teacher should be, but also to inspire, at least for me, inspire me to become a better teacher and a better scholar. So there are a couple of things I'll mention. So the question is for the rest of our panel, what is it about Joel as a human that you're going to take with you that inspired you to be better, or that inspired your work or inspired you? And there are a couple things that I can think of, so I'll start as people think. One is that Joel believed in being a citizen or a contributing citizen of your community. Joel was a staunch believer in the state of Israel and in fighting anti-Semitism, which he was sometimes a lonely voice in sticking up for in an academic community. We often had conversations. We often have conversations about that. I having gone to Jewish day school when I was younger, and being the son of a clergyman and growing up very religious, but no longer religious now, we had lots of conversations about our connection to organized Judaism and the state of Israel. And his passion for his community was not only outstanding, but inspirational. His passion for being a mentor was certainly inspirational. For me, he not only set the tone in our privacy community, but he was the reason why twice a year, every summer and the beginning of another semester, I'll always put out on Twitter a request or a call for any junior scholars, particularly those underrepresented in the field. You know, as a gay person, I'm particularly interested in mentoring new queer faculty to send their very early drafts to just be read by someone. And it's great for me because I get to learn what's going on in the field, and I get to meet new people. And all of that was inspired by Joel, because before even knowing who I was or how good of a scholar or what contributions I could make, he said, just show me anything. I don't care how bad it is. And my early scholarship, looking back on it, I find embarrassing to read, but he said, just share anything with me. And he said he gets more out of it than we do, because he learns more. So he is someone that I'll always look back on and remind myself to be a better mentor, a better citizen of my community, however you define your community, whether it's even intersectional, and also just a better human, someone who pays generosity forward. So I think this is a kind of a nice way for our conversation to end. So maybe if our panelists can think about ways that Joel's inspired them to be, better people. All of the people on our panel are awesome people to begin with, but we can always be better. Let's switch up the order again. Let's start with Dan this time.
Well, certainly. Well, I think most notably is just how friendly and generous Joel was to so many people. I very much remember those gatherings at Fordham where he'd bring us in and bring in some of our colleagues to discuss an article, and then have those famous meals at Rosa Mexicana. I remember that very, very well. Been to a number of those events. They were really wonderful. And just in everything he did in every way, every encounter with him was one that was interesting and productive. He was always interested in talking about ideas and scholarship, always open to reading work and commenting on work, and generous with his time. Just always willing to be a friend and mentor. And what struck me, and I didn't realize as much as I do now, is just hearing how many other people he did this for. That, you know, he was this way for so many people, and was so giving of his time and friendship to so much of our community and field. You know, it's really remarkable that he was able to engage with so many people and still produce his own work at the same time. So you know, he was really, I think, the epitome of what someone should be in this field, and someone that I've really tried to emulate, because I think that, you know, he was one who not only contributed to our field by what he wrote, but also by who he was and how many of us he helped develop. So thank you, Joel, for what you've done for us personally and also professionally.
Thank you so much, Dan. Let's do Margot and then Paul.
Thank you. So first of all, be nice, be welcoming to people, connect people, and give them platforms on which they can shine. I think Joel really emphasized, you know, believing that one's work could really matter in the world. I came into this career a little bit sideways. I was 100% convinced I was going to go work at a nonprofit, and then started realizing that I could kind of do the things I wanted to do without supervision or control of what I could cover as a topic if I went into academia. And Joel was one of the most prominent models of how to do this. I mean, we haven't talked very much about the ways in which CLIP actually changed the conversation through policy work, not just through academic work. And then last thing is have fun. I mean, I think it can be very easy in academia to get caught up in what happens on the panels, particularly when we're on Zoom, and to forget what happens after or between the panels. And Joel was very much a proponent of trying to deliberately foster those community spaces, again, in service of being nice, being welcoming, and changing the world.
Thanks, Margot. Let's hear from Paul, Kathy, and then we'll wrap up with some final remarks from Judge Chin.
Okay, so you know, Margot, I also have fun on my list. So what did I learn from Joel? My kind of list, and this is also, I want to amplify what Ari said about community. So community, fun, and family. And so regarding community, what I would like to add is how important Fordham was to Joel and how much he contributed there. And so he played a very important role. And so I've talked about how Joel could be stubborn and diplomatic at the same time. And so Joel was played a very important administrative role at Fordham, both as the head of the faculty senate and then as a important vice president for academic affairs, where he got a separate office on the Rose Hill campus. So when I was trying to track him down, I had all kinds of different phone numbers that I would try. And Dan, this was pre-cell phone days, just to date it a little bit more. So he was just tireless. And during the memorial service for Joel in May 2020, one of the first speakers was from the top leadership of Fordham. And he said that Joel deeply embodied Jesuit values. And, you know, initially I smiled because, as Ari said, Joel was very proud of being Jewish. Indeed, his wedding gift from my wife, Steffi, and me, wedding gift from Pascal and Joel, was a beautiful set of Shabbos traveling candlesticks, which was just so thoughtful. And so embodying Jesuit values, and I could feel Joel smiling at that, but I checked. And Fordham says Jesuit values are someone who leads a, quote, virtuous life characterized by personal responsibility, respect, forgiveness, compassion, a habit of reflection, and the integration of body, mind, and soul. So Joel was a Jesuit all along, and we didn't know. Second, fun. Joel and I had so much fun over the years. And, you know, he was somebody who was completely not a snob, but enjoyed everything. And so when I think back, we had great meals in Paris. We had beer and mussels in Brussels on the Grand Place. And we had pizza in Short Hills, New Jersey. And it was all great, and it was all fun, and Joel sparkled. And finally, family. So I was so touched. I showed you before our book from the 1990s, and it's dedicated to Pascal, Jeremy, and David. And you three gave him so much joy. You were his rock. He taught me so much about the importance of family. And then at the end of his life, his getting to know his beautiful grandchildren gave him such joy. Judge Chen mentioned Joel's great smile, and Pascal, Jeremy, and David, the smiles of Joel with the grandchildren were, I think, the biggest smiles I've ever seen on Joel's face. So bless you. And again, community, Jesuit values, and family. No, not community, community, fun, and family, and Jesuit values.
On the fun part, Joel was always really tickled by my love of dogs and dog stuffed animals, as you can see behind me. I have a dog, but she's not here right now. And when we were sometimes walking on the street of New York, we would be in the middle of a very intellectual conversation, and I would see an adorable puppy, and I would be like, oh my God. And like my voice would go up a couple of octaves, and he would always just laugh at that. And he was very, he loved that. He said, you exude joy whenever you see a dog. And he really loved that. Kathy, and then just Judge.
Well, a lot of what I will say is just to second, third, fourth, or whatever, many of the things that that everyone has already said. I think one thing I actually somehow haven't mentioned yet is I spent a semester as a visiting professor at Fordham. And that was a really great experience. It was 2008, I think. And it was when CLIP was kind of still new-ish, I think. And so just getting to see what was going on with CLIP and being involved in some of the events there was very inspirational to me, and some things I'm trying to do now and later. But I actually wanted to mention something rather completely like unrelated to my professional stuff, which is that my daughter got her law degree at Fordham, where actually Olivier Sylvain was one of her very favorite professors. And she never had Joel as a professor because she was not interested in, you know, all this information privacy and all that kind of stuff. But I just remember Joel said, and Joel was very busy at that time. I think he was in his vice president, academic, whatever, that he was doing all of that. And I just remember him saying to me, if your daughter ever has any questions or needs any, has anything she wants to ask, please just have her call me, which of course she would never have done in a million years. But I really had the feeling that, first of all, he cared and he would have answered, he would have also, that he probably would have done that for any student. It just had that feeling to it. And I thought, of course, anyone could say that, but I really thought he meant it. He really cared. Here was one person who was going to be a student at Fordham, where she graduated and had a great time and everything was great. But that he just said, if she needs anything, and it made no difference to her because she would never have done it. But for me as the mom, it was nice to know that somebody would have cared. And other people at Fordham did help her out and care, but that just stuck out to me as a kind of family and caring about students story.
Thank you, Kathy. And now Judge Chen.
Yeah, thank you for the final word, Ari, and thanks for organizing this. I've very much enjoyed listening to the panelists. And the attributes that they have listed, be nice, be virtuous, eat well, family, community. These are the attributes of a good person. And that's what Joel was. He was a good person. I would just add two One is take chances. You know, judges by nature, I think, are somewhat cautious, but just Joel took a lot of chances and, you know, took a lot of positions that maybe were controversial, certainly back when he first took them. And I think it was just a really good thing to do. And then the final one I would add is be kind. You know, sometimes judges wind up being tough, and I think it's really important for us also to be kind. Thank you again.
Thank you, Judge Chin, and thanks to all the members of our panel. It's been an honor for me to be a part of this, to be with you, to be with all 200 and some odd of you to celebrate and remember Joel. Thank you to Fordham for making sure this happened. And now I'm going to hand this back to Olivier to wrap up. Thank you so much, everyone.
Thank you, Ari. What a wonderful tribute. I'm so grateful to all of you for joining us and contributing in the way you have. I'm not going to, I'd love to have responses to everything some of you have said, but I'm not going to do that since we are running out of time. There are a couple of things I do want to note. First, that Bill Traynor is here. Bill is now the dean at Georgetown, but he was the dean at Fordham. And he heard Joel's vision about CLIP and information law and policy early on and supported him. So I think I just thought I would mention that. Paul, you were speaking of, you know, Fordham luminaries. You were talking about a senior person at Fordham who was talking about Joel as a Jesuit. That was no less than our president, the Fordham University president, the priest Joseph McShane, and Father McShane, and I think that it mattered a great deal that he participated in that event. Anyway, so I want to thank everyone for attending. Joel's legacy lives on. His memory is a blessing. I do want to note that today the FTC is holding here a workshop on dark patterns, which is very much in my mind focused on design and the ways in which it influences behavior. So his work continues in that regard without question. And of course, through CLIP and Tom's leadership. So thanks to everyone. I'm really grateful to the panelists and wonderful to see all of you join us today. Bye-bye.